Evening, folks. We're back again. Previously I talked to you about certain aspects of banking fraud and wanted to start elaborating on some things that you can do to protect yourself. I have a letter here before me that came up rather quickly when I went to a Google search. It's amazing, like I said before, how quickly you can come up with information that pertains directly to what you're trying to do. And the whole aspect of what we're trying to do here is protect ourselves from banking fraud and foreclosure. Well, this pertains very specifically to what you're trying to do, what I'm trying to do. So what I'm going to do is I'm going to direct you to this site after I get done reading a letter to you. It's kind of like a template. It has various court cases cited that basically the banks are supposed to be adhering to when they write up a contract with you. But none of this is actually being done, and one of the sad things about this is generally you and I, as people that are trying to buy a home or get credit via a credit card or purchase a car or anything of that nature, we don't realize what the legalities are. Who's putting up the money for your loan, for instance? Is it legal tender? A lot of people don't know that what's created electronically is not legal, and you're going to find out through this letter and more information that I'm going to provide in the future that it is indeed not legal, and you can fight a court case with the information that you're going to be seeing here tonight. I'm also going to try to direct you to some more court cases and supportive documentation and information as we progress in further videos. So as it starts, I'm going to go ahead and read this off to you, and it's going to come back later throughout this video. You really got to pay attention to it and then make a decision. Is this or something similar to it something that you would like to present to a lawyer or law firm to represent you in your argument as to whether or not a banking institution or lender has the right to collect money from you? Well, we'll see. See what you think. The whole idea in presenting this to you is to bring this to your attention, because like I said before, you're not going to be able to find this information or hear about it over the major networks, because basically they own the networks. The banking institutions, they own us. They own the information networks, everything that would be coming to you over the air, over TV, the radio. You're not going to hear anything about this. But you're hearing about it here, so that maybe we can develop some interest in the area and an incentive to dig deeper for yourselves. This is protection for us. Again, this is our forum, so here we go. I'm going to get it started here. I received without prejudice your letter of such and such date, where you did not prove true and correct any of the demands in my notice and demand of such and such a date, to wit, legal documentation here. Essentially, you did not, 1, prove that you have not created, loaned, and charged me interest on created credit as per several court decisions that have found this practice fraudulent and usurious. First case in point, First National Bank versus Monroe, 59 SE 1123. St. Louis Savings Bank versus Parmelis, 95 U.S. 557. American Express Company versus Citizens State Bank, 181 Wisconsin, 172. And 2. Prove that you have not created this credit as a bookkeeping entry, such as was done in the case of First National Bank of Montgomery versus Jerome Daly, Credit River, Minnesota, 12/7/1968. This is a court case, and the plaintiff lost. The plaintiff was the bank. Plaintiff's act of creating credit is not authorized by the Constitution and laws of the United States, is unconstitutional and void, and is not a lawful consideration in the eyes of the law to support anything or upon which any lawful rights can be built. The bank had given nothing, therefore nothing was all they were entitled to get back. And other such court cases as 3. Prove that you did not use fractional reserve banking procedures where you created money out of nothing on your books and records for this account. And 4. Prove that you have given lawful consideration. Again, read what lawful consideration is. And substance on this account as per the Constitution of the United States of America. Check this. Article 1, Section 10(1), where it discusses gold and silver coin. And as per the Constitution of the State of California, 1849, Article 4, Section 34, for the deposit of gold and silver, but no such association shall make, issue, or put into circulation any bill, check, ticket, certificate, promissory note, or other paper, or the paper of any bank to circulate as money. And Article 4, Section 35, the legislature of this state shall prohibit by law any person or persons, association, company, or corporation from exercising the privileges of banking or creating paper to circulate as money. And as per the U.S. Supreme Court decision clearly designating gold and silver coin to be lawful money in Bronson versus Rhodes, 74 U.S. 229, 247, 19L, ED 141. Lawful money of the United States could only be gold and silver coin, or that which by law is made its equivalent, so as to be exchangeable, therefore at par and on demand, and does not include a currency which, though nominally exchangeable for coin at its face value, is not redeemable on demand. And as evidence, when an act of Congress in 1862 created United States notes, and in doing so stated that coin, gold and silver, is the only lawful money as opposed to creation by act of legislature, Congress, and as stated in Perry versus Washburn, 20, California, 318. And 5. Prove that you have complied completely with the Monetary Control Act of 1980. This is retrievable on Google. I suggest that you read it. Again, prove that you have complied completely with the Monetary Control Act of 1980. Most banks can't do this. 6. Prove that you have a proper charter to operate within California. Hey, check and see if your institution that gave you the loan can actually do this. 7. Prove that you have been properly bonded to operate within California. Some of them can't. 8. Prove that you are complying completely with the laws of the land in California and the Constitution of California of 1849, and not operating under laws of any foreign country or entity such as the District of Columbia or any other foreign country or entity regarding this account, your account. 9. Prove that you did fully disclose all of the foregoing in any agreement or contract made with me. And because you did not prove the foregoing to be true and correct, no debt to you or contract with you exists, no matter what I signed or ever existed. This supposed debt is void. You must now make my person whole by returning the entire amount paid to you under the heading of principal and interest, and then enter a zero balance on this account that I supposedly hold with you, and that you close and cancel this account forthwith, and correct with withdrawal of any and all information from any credit reporting agency that may have financial information for this account on me, or whoever it is that has this. I hereby invoke the doctrine of Estoppel, or E-S-T-O-P-P-E-L. I hereby invoke the California Constitution of 1849, and I hereby invoke the Constitution of the United States of America on you, the banking institution. If you continue to try to extract any money from my person, I'll consider it attempted extortion and or embezzlement, and will bring lawful action on any such crime. There may also be issues of postal fraud. Further, collection activity will be considered harassment and may constitute accessory to crime, personally for any collection agent. I reserve all rights and any other lawful remedies necessary to make my person whole. I will also require a list of all of your officers and their addressees, well, their addresses wherever they live, the name and address of your bonding company and the bond account number, and a certified copy of your charter from California, making them legally operational in your state, California. Make all correspondence with me in writing. Do not telephone. You don't want to be harassed. Done with express reservation of all my rights in law, equity, and all other natures of law, all rights reserved. Signed by you. This is so important when you consider trying to solicit a law firm or attorney to work with you. You want to show them that you do know something about what you're talking about, but you want to solicit them specifically to help you with this. So knowing that they have, the attorney has you as a partner basically in research of your case and knowledge of your case, what your rights are, what your legal backings would be, what case history is out there that supports your case. Well, all the questions that were imposed here by this letter to a banking institution are basically asking them, hey, are you complying with the law? Is there law that supports what you're trying to do to me? Well, where this specifically fits in with mortgage laws is, hey, we discussed consideration previously. All right, what's the bank putting up as collateral? The money they put out to give to whoever it is you're purchasing the home or mortgage from. What are they doing? What are they putting out there? They're not putting out anything for you. They're just basically making documentation, creating the money that they're putting out, supposedly to whoever it is you're buying from, out of thin air. All right, but you're putting something tangible back to purchase. Okay, we're gonna close here for the moment.